A sub-S corporation, that's where you form a corporation under your corporate statute in your state. It's a regular corporation. It's called a C Corp. But the sub-S is simply a categorization that exists for purposes of federal taxes, and it impacts state taxes. But for federal tax purposes, you do this election. You say, yes, I'm a C corporation, but I don't want to be taxed like a C corporation. I want to be taxed like an individual. So it's kind of the best of all worlds. You have all the insulation that you would have of having a corporation. At the same time, you get the advantages that individuals have in terms of the tax situation. You know, a corporate form typically means, if it's done properly, it means that you're going to be paying double taxation. Now, this is a C Corp. So that whenever you think of large corporations, these are corporations that earn money. The entity itself has a net income. So let's say that the corporation earns $1 million in 2008. Well, that corporation will be taxed on that $1 million. Now, when it distributes that in the form of dividends, that's the way it distributes its earnings to its owners, its shareholders. When it distributes that, guess who now has income? The various shareholders. So now the shareholders, if it distributed the entire $1 million, would have to recognize $1 million in total, $1 million in income, and they pay taxes on that. So in large part, it's this double taxation problem that make many people avoid this notion of a C Corp. So when I talk to you about entities, for the most part, I'm jumping to the conclusion that your business would be of a sort that you would want to choose one of these alternatives to a traditional C Corp. And there are several of them. The LLC is becoming increasingly popular. There was a time just 10 years or so ago where a number of states didn't recognize the LLC. Well, now it does. And I think in all 50 states, don't hold me to this, but I think all 50 states recognize the LLC, and it's a form that's available to you. And again, it's the best of all worlds. An LLC allows you to have the protection from liability so that if you're engaged in activities as an entity and someone sues you, then they can only sue the entity. Now, that still may not be a happy situation because your entity may have some assets. But what this claimant, this creditor, cannot get to is what you own personally. So this entity stands as a sort of wall between you and the other assets that you hold, your home and maybe your investments and other such assets. So it's critical to make the selection of the entity you want to go with and get it in place. Now, I have to pause here and add some things that if you don't follow up and do these additional things, it can be pointless to have this entity. Notoriously, I can tell you, people form entities because it's so easy to do. You can have an entity in an hour, well, a couple of hours. You could have an entity in place, literally, in most states. And once you've done that, though, you have to think, well, gee, what do I do now to assure that this is recognized, that this is honored? Well, you have some obligations, and these obligations make sense. If you were a customer or you were dealing with an entity, you would think that these obligations should be required of that person that owns that entity, that shareholder or that partner, whatever it may be. And among those would be that they do business in that form, that if they sign a document and they intend to take shelter in that entity, then they have to sign as president or as principal, whatever officer it might be of this entity, and then your name. What that clarifies is that the person signing that is a person on behalf of the entity. So essentially the contract is with the entity. It's not with the person, individual who signed it. So if you're a vice president or a president of one of the Southwestern Bell entities and you sign a document, there's no danger that you individually and your family would be sued if something went wrong with Southwestern Bell, which may not be a particularly good bet at this moment anyway. But the whole idea is that you want to be able to sign these documents, to conduct business, and do it knowing that if things go south, if this business does not succeed as you expect it to, if someone gets injured on the job, whatever source there might be for a claim or litigation, you want to sleep at night knowing that you personally are protected. Those things outside the entity are protected. Another thing, though, that you have to think about, and that's whether you're engaging in activities that are beyond the scope of the entity. Now, this generally doesn't come up, but I want to mention it. Whenever you form an entity, you have to state in your organizing documents what the purpose of the entity is. Now, the general practice is to put the broadest purposes possible, to engage in the practice or engage in business and commerce. These phrases that are intended to capture the widest range of profit-seeking or business activity. That allows you to, if you start a flower shop, to decide, gee, I think we will start selling an inventory of Halloween presents. I mean, it can be a variety of things that you can do, and these will all be included under this same umbrella. But if in your organizational documents you state a purpose that is more narrow, then you can be guilty of what's called ultra vires, and you can ignore the phrase. But what it means is that you've gone beyond the scope of the entity, and as a result, that activity is not protected. Another thing let me call your attention to when you're thinking about entities is you got to stay current on your filings. You have to file franchise forms, annual updates, whatever your state requires that you do to attend to the details of your entity. There's certain administrative requirements. You've got to meet those, and that keeps it in good standing. If you fail to file these annual documents, then your charter can be pulled, or your corporation can be not in good standing, which can jeopardize the protection that it's intended to provide. So always be sure that you've hired an accountant or a lawyer who's following up and filing the necessary forms on an annual basis or a quarterly basis, as the case may be, with your appropriate state agency, which is typically the Secretary of State. So I said I could say a whole lot more about the entities. I guess I'm going to stop there, but enough is said perhaps for you to emphasize that on your laundry list there has to be consideration of having the appropriate entity in place. What else would I suggest? Contracts. Now this is kind of an unimaginative suggestion, but it's powerful, and it's very simple. Whenever you do business with people, whenever you have relationships with people, often in the modern corporate America, modern business environment, those are in the form of contracts. Whenever you buy a car, whenever you even make arrangements to buy a house, or you make arrangements for improvement of that house, or you decide that you're going to take a trip, you sign a contract. Now many of these contracts are what's called adhesion contracts, meaning the reality is you did not, in a sort of free way, negotiate the terms of that document. That's a fiction, and the law is full of fictions. But the fiction of the law is that any time that you do business with an entity, and there's this written form, or even it can be verbal in many cases, there's this understanding, and that's called a contract. And the theory of contract law is that you've arrived at that through a sort of give and take negotiation, and that it represents the deal of the parties that's arrived at freely. But we all know that that's not reality. The reality is that you have disproportionate bargaining power, and that many of the people with whom you do business, or the entities with whom you do business, have substantially more power than you do, and you have no ability to influence the contents of that contract. So that's the reason it's called an adhesion contract. And I'll tell you, that's the reason, for good or bad, a number of juries around the country stand quite ready to ignore that. And as a result, we have this litigation epidemic in America, and it accounts for trillions of dollars of cost to the economy. But whatever your feelings about that, you can tell what mine are. But in any case, what are your feelings, whatever they are, the reality is that these contracts are executed on a regular basis throughout our day whenever we go about our lives. Now, some of the contracts, though, you do have the ability to influence. And these are contracts that are closer to that ideal, in which you do negotiate with others to arrive at the terms of your bargain. And when you have that sort of contract, then there is an opportunity to influence its contents. And that's when you can arrange for the assumption of risk in certain cases. You can have indemnity and hold harmless clauses. What this means is that you're saying, look, if things don't go as planned here, you can't sue me, or you're to hold me harmless, which means if I get sued by a third party relating to this activity, this deal, whatever it is, then you agree to pay me back. That's an indemnity or hold harmless clause. It's very common in business environment. Those are terms that you can often include in the contract. Now, I won't distract us here by talking about the circumstances that are exceptions to that. And there are public policy rules that limit the ability of you as a business person, or even you as a consumer, having certain things in your contracts. So it's not as if you have an unfettered opportunity to have whatever terms you want in your contracts as you go about your day. The law does provide certain parameters. But still, you want to explore, what are the limits of those parameters. If you sign a contract with somebody to do yard work at your house, Do you ever think about what are the implications if there's an injury? Will I have liability personally? Will my homeowner's policy cover that?